Wonderful. And we will be recording this presentation so that if you'd like to view it later, it will be available on our website, as well as some additional resources that we'll talk about in a little bit. And we'll go here. Bob, why do we have these beautiful children here?
Because they are the love of our lives, and at that age they are certainly that. I just became a grandparent, so I can really appreciate the youthful exuberance being shown there. So yes, that's why we have them. They're our loved ones. They're the ones that we take care of and take them all the way up until they are 17 and 364 days.
That's right. So until they reach the age of 18, we're making all of their legal and medical decisions for them. But then once they hit that magic age of 18, they are their own individual. And as my kids tell me, even though they're not yet 18, they're like, when I become big, I'm going to make my own decisions. Oh, okay. They're going to make their own decisions. But what if something happens to them? And the purpose of this presentation is really to talk about, when your child reaches the age of 18, they truly are their own individual. All of their private information is private to them. Just because we're their parents does not necessarily mean that we have the authority or the right to make decisions on their behalf. Yeah. So God forbid, what if, let's just say, as an example, Karishma, let's just say something happens to one of my children and they're 18 years old. Can I go and just make healthcare decisions for them?
No, you cannot, because once they hit 18, obviously they're legally an adult. But if they have a healthcare directive in place that appoints you as their healthcare agent, then you can talk to the medical professionals and make decisions on their behalf.
That's beautiful. And this is an example of our advanced healthcare directive. It does have some very detailed instructions, but this is what we encourage our families to put in place, even for their children who are recently turned 18 years old. And it's not just for the college bound kids. It's for any kid who reaches the age of 18 and doesn't have what we call in our office incapacity documents. Because, if something happens to our kids and they're in the hospital and somebody needs to make medical decisions for them, we definitely want somebody to have authority, especially the parents, to have authority over that child so that they're going to be making the medical decisions that fit their child the best. And this next set of slides will actually walk us through our advanced healthcare directive.
I was just going to add, it's I don't know, it's not strange, but it is, what the law in California says, that up until our 18th birthday, we are essentially incompetent. If I was 17 and I wanted to go out and contract to buy that Corvette, I don't have authority to sign that under normal conditions. I don't have the power to sign that contract. It's not a binding contract. Same thing with medical care. Our parents generally direct our medical care until we're 18. Now, there are some exceptions under that rule in California, but for the most part, medical care is directed by the parents. But all of a sudden, we hit that magic age of 18, and now, poof, we're adults. And we are charged with the responsibilities of being an adult, which include, monitoring our own healthcare, enrolling ourselves in school, getting credit cards, buying the Corvette.
Oh, no.
Doing all those things. Yeah. So I'm sorry, I just had to throw that in there.
No, that's exactly why we need to have this conversation. And for those who are interested in having their loved ones complete incapacity documents like an advanced healthcare directive, it starts off fairly simply. We have our John Doe here, who is assigned as the designated agent to make decisions for the benefit of the person creating this document. If not John, then we've got Sue. So here we just have a series of individuals that would be authorized to make decisions for that 18-year-old if they were ever in the hospital or in a medical situation and couldn't make their own decisions. Okay. And
can I just throw out one point, and that would be, because this comes up a lot, I'm sure, and Karishma and Roxanne, I'm sure you see this with our clients. They'll say, well, who needs a copy of this? I want to get a copy of this to the doctor, but I think it's important to know who should really have a copy of these healthcare directives.
Your agents.
Thank you. Yes. In a word, that's it, right? It's the agents that need to have it because they're the ones that are going to be called upon, and they're the ones that need to show that they have the authority to act.
Exactly.
So that's, and a lot of people, I just don't see that. And I can see why. They go, well, if I get it with my doctor, then my doctor has it. Well, that assumes that we're hurt or need that to be in play, we're near our doctor. But what if we're on a trip over in Europe or in visiting Washington, D.C. or something, and something goes wrong? Then you need, your agent's going to be called upon, and having that just with your doctor is not going to satisfy that.
That's right. Excellent, thank you. And here we also talk about when the document becomes effective. Karishma, what kind of options do we have?
Sure. So the document, so on this slide, we are talking about 1.3, so right at the top. So your agent's authority could become effective either upon incapacity or immediately. So on the screen, just under the yellow lines, it says, if I mark this box, then my agent's authority to make healthcare decisions for me takes effect immediately. So it's one of two options.
Very good.
Right.
Beautiful.
Right underneath that talks about your agent's obligations. And so here it basically states that your agent, to the extent that your wishes are unknown, your agent they are obligated to make the decisions in your best interest and in accordance and in guidance with what you would want and what's going to be in your best interest. So you're trusting these individuals that they are going to make the right calls and advocate for you when you are unable to advocate for yourself.
And Bob, what is the purpose of this part 2? What do they mean by end of life decisions?
Well, and that's really, and then if you go back up to what Karishma was talking about in the agent's obligation, what we're talking about for end of life, and it's essentially when a physician or a physician panel reaches the determination that Bob's life is not likely to continue, that his condition is terminal, that he has a limited, based on their best assessment, he has a limited time left on the planet, then the doctors will often approach the healthcare agent to determine did Bob complete a healthcare directive? Do you have a copy of it? Is it signed and dated and notarized or witnessed? And if so, what did Bob want to have happen if he found himself in this condition and could not speak for himself? And so, the choice not to prolong life or the choice to prolong life is an indicator here as to how I would want things to go if I was unable to make that call. And I think what's so important about the agent's obligation, and we stress this in our meetings with our clients, you really want to have a discussion with your healthcare agent about how you would want things to go. Nobody wants to be in a situation where a decision has to be made for us when we're not present. But we want to make sure that we've armed our agents with the understanding of what we want so that they can advocate for us. How can your agent be a good advocate if they don't know what you want? So it's not necessarily a pleasant discussion. I think that once you get into that discussion, it is okay. And out on the back porch in the sun with a glass of wine in the afternoon is not a bad time to do it. I'm going to get off my soapbox now, Karishma.
And here it's important to know that you can articulate your wishes with regard to pain relief. So down here at the very bottom, there is a provision that provides for alleviation from pain, even if it does hasten death. Or if you have restrictions as to pain medication, you can articulate those here. Okay. So we'll move to the next section. Did that work? Here we go. Okay, excellent. So if you have other wishes, we're going to fill that out here. If you have a desire to donate organs at your passing here, and then some folks like to donate or contribute their body to science or therapy or research, that's available here. And then, we used to ask clients for the information, the contact information for their primary physician, but these days we seem to be changing our physicians so often that it's we just ask our clients to leave this part blank. And we'll just wrap it up with, we're signing our name. Earlier, Bob talked about, is it a validly executed document? Is it signed, dated, and notarized? So that's here. And of course, we have, in lieu of the prior, the notarization, you can have witnesses. There's an additional statement as to a witness. And then if an individual is signing this in a living assisted living facility, we have a statement from a patient advocate or a ombudsman.
Yeah.
And if you're interested in obtaining your own form, you can actually find it on our website. It's under the resources tab to download and complete on your own. Just make sure that you fill it out properly, sign, date, notarize.
Yeah, or witness the witnesses, but you do want to, medical, when I worked with a woman whose husband, and she taught doctors at medical students at Stanford Hospital, and whether this is true now or not, I don't know, but in any event, one of the things they were instructed on was to review the healthcare directive to make sure it was signed, dated, and either notarized or witnessed. That's what you need to have a valid healthcare directive. And so want to make sure you get those things done and done right. And if you do use the witnesses, make sure you read all the way through that, because one of the witnesses has to sign in 2 places. Yeah.
That's absolutely crucial. Thank you. And that has to do with all of the healthcare decisions that one would make for that young adult in the event of their incapacity. But what about financial matters? We have our second part of our incapacity documents. Karishma, is this something that you help your clients put together?
Yes, absolutely. So the power of attorney for finances is an incapacity document that, as it says in the title, it allows you to act on the principal's behalf to manage their finances. And this would be things like if there is no trust, so bank accounts, life insurance, retirement, and you would be able to basically control the assets and manage them on behalf of the individual who is incapacitated.
Exactly. And one of the things that I've seen happen is, parents oftentimes are the ones paying for college tuition. But if for whatever reason the child becomes incapacitated and the parent needs to obtain financial statements, the institution may not necessarily give that to you because the child is now 18. Are you privy to that information? If you had a power of attorney, it wouldn't be an issue.
Yeah. And there can be times, because our children that are over 18, particularly if they're off to college, they're not necessarily in the area. So things can come up from time to time where you need a child's signature on a document. It may be to release a savings bond or whatever it may be. That power of attorney allows the parents to sign on behalf of the child on those documents. So it's a convenience factor. These days with so much stuff moving through the web, it may not be as important as it once was, but it is it still has a definite place in terms of planning for somebody that's over 18.
Absolutely. That's a really good point, Bob. Thank you. And then, of course, because we are estate planning attorneys, and so it's not just incapacity, but in the event of someone passing away, do they have some sort of estate plan as to what happens to their things once they leave this planet? Here, maybe a last will and testament would be appropriate for that young adult. Okay.
Let's see, do we want to talk about what happens if a child, a single child does not name somebody, where the property will end up, their property will end up? We have had that come up in the office a couple of times.
A couple of times?
Sadly, yeah, sadly.
Before we get to that, I'm going to quickly go back to the power of attorney and say one quick thing. So we discussed on the healthcare directive that it's effective either during incapacity or effective immediately. And the same thing goes for the power of attorney for finances. But you can make it effective immediately or upon incapacity. So that would be at your comfort level and discretion.
Yeah. The 18-year-olds.
Yes, the 18-year-old. I'm sorry, yes, not the viewers, the 18-year-old.
Yeah. I can tell you, my son has one, and my son has, we have immediate access, so we can use it like right now. We don't have to have a disability certificate to use it on his behalf, but you're right. That's a good point, Karishma. That's going to be how families determine that. But generally, I think you want it to be immediately effective. So you have that convenience factor of being able to use it if the child is out of
Right.
it. But yeah, it's a good point. Very good point.
Absolutely. All right. So Bob, what happens when a child passes and what happens to their stuff?
Yeah, well, if they're like me, they don't have very much stuff. They got a lot of student debt to start with, but so generally that's not a significant issue. But so I kind of think of a will for real young, just over 18 is probably in general not necessarily critical as it is the incapacity documents, but it can still be there. Your question to me is what happens if somebody just over the age of 18 or whatever it may be passes away without a will? And the answer is that the state of California gives them a will. And as I recall, it will go to the parents. Anything will go to the parents. And if the parents aren't there, it would go to the siblings. Yeah. So it follows the bloodline, basically.
Governor Gavin's estate plan for us.
That's it. That's it.
Yep.
That of course assumes no children, no spouse.
That's a good point.
So.
That's a good point. All right. Beautiful. So when children turn 18 years of age in the United States, there actually are service registration requirements. Young men at the age of 18 or to 30 must register for selective service. And women can serve in the military, but they're not required to register for selective service.
Yeah, and there are some when I last looked into this, there are some fairly significant penalties for not registering with the selective service.
Oh,
And I don't think it's really maybe under the current situation, it's more on our minds than it has been in a while, but it is something that is required of 18-year-old males still. Yes.
it is. Yeah. So if we do not have incapacity documents like the ones that we just talked about, and we have somebody who maybe doesn't have the ability to execute those types of incapacity documents, but they are themselves incapacitated in that they cannot make their own decisions, there is a process by which parents can take control over the child's healthcare decisions and their financial decisions. And that's a formal process that actually requires a court involvement, and that's called a conservatorship. Okay. And here we've just mentioned the limited conservatorship if the child has had a disability before the age of 18. And so now they're sort of aging up into adulthood. This is a type of conservatorship that can be obtained by parents so they can continue making decisions for their children.
Yeah.
And of course, we also have the informal, which is that advanced healthcare directive that we discussed in detail.
Yeah. If it just as a note, if you remember, I think it was you, Karishma, who went over about you could check the box to make the advanced healthcare directive immediately effective as opposed to upon incapacity.
Right.
So if we're going to, my grandniece is a Down syndrome child, and she's got good developmental instincts, but she is going to be permanently impaired, or under current medical conditions she will be probably have her mentation is going to be limited, but she can sign her name and she understands things. And so I would be thinking for my nephew and his wife that when she's 16 now, going to be 16, so coming up pretty soon, they'll need to make a determination as to whether they want to go with a formal conservatorship or whether they want to use an informal method. And this is my view on the world, and it's attorneys are going to differ on this, and the law may differ on it, but from my way of thinking, if I have a special needs individual that's high functioning and is not a danger to him or herself or to society, then
Right.
I think the informal way is a way that allows the family to avoid the significant costs of a conservatorship and accomplishes the same technique. Now, and again, it's a case-by-case basis. We look at these on a case-by-case basis to make a decision as to whether it's appropriate or not, and work with the parents on that, of course. So, but it is one way to go. Yeah. Sorry for that long-winded.
No, thank you for sharing, Bob. And I think Karishma and I tend to think the same way as you in that, the informal process of having these incapacity documents like the Advanced Healthcare Directive and this next slide, the power of attorney, it gives the family a lot more dignity than going through the court system too.
Yeah. Yeah, and I've actually, so I have followed with clients, I put them in these plans and, they've been able to use like the power of attorney for finances with the Social Security Administration and that type of thing. So it's helped out and, to keep benefits going. And then they can speak on behalf of the child rather than forcing the 18-year-old to try to go in and explain why they're available for benefits. And so found it to be effective there. The healthcare directive, so that, the parent wants to go into the parent may want to go into the exam room to find out what's going on. Well, according to Hoyle, you really need to have, the Advanced Healthcare Directive provides the documentation that allows you to go into the room with the adult. There is an argument that wow, you mean, why can't the child give that okay? Why do I need a document? I agree. There is some a little bit of ambiguity there, or why do you need one without the other? But we've had circumstances where having the healthcare directive worked to get the parent in with the child. So it gives the doctor, a basis to allow that to happen. There's a document that supports that. So
Absolutely. Okay, and so other forms of protection for our children, because they're 18, they can marry. Perhaps we would encourage our children who might be getting married to enter into a prenuptial agreement. I'm not saying I'm a tiger parent, just saying prenups are a good thing, okay?
Yes.
And we also can protect our children from creditors and predators. Who is the most likely creditor in a child's life? Karishma, what do you think?
Loans.
What's that?
Student loans.
Student loans. I love that. That's one. Bob, how about from your perspective?
Yeah, I think when we're using creditors there, we're really talking about people that have not so much the student loans, although I appreciate saying Karishma. It's the the unfortunate accident on Highway 101 where our child rear ends a bus full of plaintiff lawyers and they all sue because they have whiplash, and the insurance coverage may be over that amount. The insurance coverage may not cover all those claims, and therefore the inheritance going to the children will have some protection around it, some protection. Yeah.
Beautiful. And of course, don't forget the beneficiary designations, not only for your own financial assets that may have designations, but that child, if that child has an investment account that they opened when they're 6 years old and you've been helping them invest in it, and there's a significant amount of money in there, without a full-blown estate plan, you can use the beneficiary designation. So if something happens to them and they leave this planet, it's going to go smoothly and distributed smoothly to loved ones rather than having potentially a court process get involved.
Right. And we typically think about beneficiary designations for life insurance and retirement plans. And, I was telling Karishma and Roxanne, I was on the phone today with clients that have a life insurance policy. The beneficiary has been designated as the estate, which means it'll have to go through a probate process. So that generally would not be a recommended, but what we see most of the time is that nobody has been appointed or nobody has been designated. And typically if nobody has been designated, then the estate becomes the beneficiary in most instances, which forces a probate. So an asset that should pass like that passes with a lot of time and expense involved.
Very slowly, yes.
Not a good result.
It's massaged through the court system.
Yeah.
All right. And that brings us to any questions that we might have from our viewers today.
Yes, we do have one.
Okay.
This person asks, if the document gives primary physician ability to judge you incompetent to trigger these powers, and when you leave the primary physician blank, what happens?
Oh, I see. Yeah. You want to go?
Right.
All right. Well, it's actually going to be the treating or attending physician that's going to make that determination. Again, incapacity is essentially a medical determination. The treating physician, your primary physician, may be in Redwood City, and the accident occurred in Texas, and therefore the treating physician in Texas is going to make that determination. And the accident, if I'm laying in bed unconscious, it's a pretty easy call. If I'm woozy and goofy, then it becomes a more difficult call. But that's who makes that call. It's the attending or treating physician. Yeah.
Great question. All right, so now let's recap, because we always advocate comprehensive coverage, comprehensive estate plan. So we've got a revocable living trust for those who need a trust, a will, if they have a trust, it would be a pour over will. But let's focus for these young adults. We really want to make sure they have incapacity documents in place, maybe effective immediately, maybe effective upon incapacity. That is unique to the person making those decisions, but it'll be the Advanced Healthcare Directive and of course the power of attorney for finances. And with that, I believe our next slide is for Morgan and to announce one of our events.
Yes, thank you, Roxanne. Just as a reminder to everyone joining here who may be new or just needs an update on this information, if you want to keep updated on all information coming out of McDowall Cotter, please feel free to follow us on our newsletter. If you have any questions about getting registered for that, please feel free to email me. I can go ahead and register you, or you can register yourself on our website. Very simple process, just email, first and last name, boom, you're done. And lastly, if the newsletter is not where you get all of your information, you can go ahead and follow us on social media. We have we are live on Twitter, Instagram, TikTok, Facebook, LinkedIn. We have a very big presence there. So if that's how you get your information, please do follow us. We post very regularly, at least once a week. And if you have any questions, you can go ahead and email me.
Perfect.
Boy, that's social media. Wow, I tell you.
And we will be hosting an incapacity document event for anybody who just is looking for incapacity documents, or if they do truly have actually a young adult turning 18 and going off into the world. That will be held on Friday, June 17th. If you're interested in more details, contact Morgan, or be on the lookout for the updated newsletter blast.
Perfect.
Fantastic. Thank you so much, everyone, for joining us today.
Thank you.
everyone.
Bye. Thank you.
Bye-bye.